All right, good afternoon, everyone. We're going to start promptly at 3. You have entered the top 3 legal issues facing cities breakout session. I'm Robin Klein, League of Oregon Cities Assistant General Counsel. We are here sponsored by Markowitz Herbold, and also there are speakers. We've got a great panel for you all. Annette Jindal, April Stone, Carrie Shepard, and Hannah Hoffman. And I'm going to let them take it away, but please welcome them today.
Thank you, Robin. Where is he? As Robin said, my name is Annette Jindal. I'm an attorney in Portland at the law firm Markowitz Herbold. My practice, I do complex civil litigation, but I have a particular focus on constitutional issues affecting state and local governments, which is in large part why I'm here today. As the slide, let me hit forward. As the slide says, the focus of what I'll be discussing today is responding to homeless encampments in the Ninth Circuit, so the West Coast, which includes Oregon. And I just want to preface the presentation by just pointing out that this is an area of the law that is very much in flux. A lot of the cases we will be discussing today have happened in the last few years. A lot of them have had significant developments in the last few months, and even some of the most significant developments have happened in the last few weeks. So this is a very cutting-edge area of the law that is rapidly developing and changing. And so it's an interesting time to be learning about it. That also means that I'm not going to have a lot of clear answers for you today because, as you all know, responding to homeless encampments is something that every city government is dealing with and is dealing with in many different ways, and the courts have not yet decided, drawn clear lines as to what is and is not permissible. I also want to offer a disclaimer. All the cases we'll be discussing are real cases. They happen in real places, and many of them happened in Oregon. For the purposes of our brief discussion today, I'm going to simplify what happened in the cases, but some of you might have been involved in them or know more about them, and so I promise I'm not intentionally leaving anything out. I'm just trying to keep things tight for discussion purposes. And finally, if you have any questions, by all means, just raise your hand. I think Robin said she's going to grab a mic and can come find you all. We'll also leave time for questions at the end, so if I sit down and you've got a burning question in there, by all means, just ask it. And with that, I think with any good legal presentation, I think it's a good idea to start with a law. So this is the 8th Amendment to the United States Constitution, and that is sort of the main law that the federal courts have relied on when responding to homeless issues. And what the 8th Amendment requires, it says that excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. And it's got a lot baked in there, but the part that we're going to talk about today is that last part, cruel and unusual punishments. And courts have interpreted that not just to limit the type of punishment that the government can mete out for a particular violation, but in fact to limit the type of conduct that can be criminalized at all. And as we'll see, courts in the Ninth Circuit have held that it violates the 8th Amendment to criminalize homeless individuals for sleeping on public property when they have nowhere else to go. And so the first key case in this area is Martin versus the city of Boise. And that's a picture of the city of Boise there. And in that case, there were more homeless individuals in the city of Boise than there were shelter beds available. Boise had on the books laws that banned sleeping on public property. And the plaintiffs were individuals who were experiencing homelessness who had been cited for sleeping on public property. The plaintiffs sued the city, and they seek what's called an injunction, which is an order from the court barring the enforcement of the law. And the holding from the court is up here on the screen. It said the 8th Amendment precludes the enforcement of a statute prohibiting sleeping outside against homeless individuals with no access to shelter. And it seems like a simple enough rule, but the court also explained that there are at least two big caveats to it. The first is that a law banning sleeping on public property could be enforced against someone that had shelter realistically available to them. Now, what does it mean for someone, any individual person, to have shelter realistically available to them? And this is going to come back to what I opened with. The case doesn't say. And so it's up to the individual cities in their individual enforcement actions to figure out what that means. The next caveat, and I think this one will be familiar to a lot of you in this room, is that in footnote 8 of Martin versus the city of Boise, and this is why you hire lawyers that go through the footnotes and find the 8th one with the special rule in it for you, it sets up, or allows for what we now call time, place, and manner restrictions. So it says, even where shelter is unavailable, an ordinance prohibiting sitting, lying, or sleeping outside at particular times or in particular locations might well be constitutionally permissible. And yet again, the case doesn't really give guidance as to what that type of ordinance might look like. It doesn't give examples of what is or is not constitutionally permissible. And so the next big case in this area, it's decided relatively recently, was the Johnson versus City of Grants Pass case. And let me go back one actually. In Johnson, the ordinances barred the sleeping with any bedding, sleeping bag, or other material on city property. So it didn't ban just sleeping on city property. You had to have some sort of material with you. And again, individuals experiencing homelessness brought a class action on behalf of themselves and other similarly situated homeless individuals, seeking to enjoin, again, the enforcement of the laws. And the district court issued a permanent injunction, largely enjoining enforcement of the ordinance. And the Johnson case was interesting because it was different from Martin in at least 3 ways. First, the law at issue did not prohibit sleeping on public property. It prohibited sleeping with bedding supplies. Second, the law dealt with civil citations, not criminal penalties. So it was an interesting legal question whether the 8th Amendment would apply at all. And the plaintiffs brought what's called a class action. So they purported not just to be trying to enforce their own rights, but to represent all similarly situated homeless individuals. But ultimately, none of these differences affected the outcome. The Ninth Circuit affirmed, relying on Martin. And up there I have those three features that we just discussed. But the story of Johnson does not end there. The city of Grants Pass asked the Ninth Circuit to reconsider the Johnson decision. They asked for it to take the case en banc, which is just a way of saying they wanted the full court, not just these 3 judges, to review the decision. The League of Oregon Cities actually supported that effort with an amicus brief that our firm worked on behalf of the league. But alas, this summer, by a narrow 1-vote margin, the Ninth Circuit declined to reconsider the case. But the Ninth Circuit did provide one helpful clarification. In previous draft or a previous version of the opinion, the Ninth Circuit had suggested that if the number of homeless individuals identified by point-in-time counts exceeded the number of shelter beds available in a city, camping and sleeping laws were unenforceable, regardless of that individual homeless individual's access to shelter. The Ninth Circuit revised the Johnson decision to sort of strike this formula out of the opinion. And I know that sounds very technical, but what it means as a practical matter is that if an individual is offered shelter or has shelter available to them and refuses it, you likely can enforce a sleeping or a camping law against that person because they're not involuntarily homeless. They have access to shelter. And so that was a helpful clarification that the en banc process was able to generate. But the story of Johnson does not end there. The city of Grants Pass petitioned the United States Supreme Court to review the case and effectively overturned both Johnson and Martin. And last month, the League of Oregon Cities again filed an amicus brief in support of that effort. And just last week, the Supreme Court directed the plaintiffs to file a response, which is a subtle indication that the justices are looking at it very seriously. And so watch this space. There will be developments here. It might be nothing. They might say, we deny certiorari and the Ninth Circuit's case law on this stands. But they might also say, no, we're going to take a second look at this, and then there will be very significant developments on the issue. So we'll know if the Supreme Court, we should know, they can grant extensions, but we should know more about what the Supreme Court is going to do with the case by the end of the year. And if they take it, there might be very significant developments in this area of the law within the next year or so. So where does that leave public policy? I think general bans on sleeping on public property are going to be difficult to enforce against all homeless individuals, especially where a city is unable to offer shelter. That seems to be the core holding of Martin and Johnson. Now, there's actually an interesting case out of San Francisco about trying to clean up specific homeless encampments. So in San Francisco, the city restricts the use of tents or other structures on public property, mainly sidewalks and parks. And the city also restricts sleeping in parks during nighttime hours, and conversely, sleeping on the sidewalk during daytime hours. San Francisco enforces these laws using targeted cleanups of specific encampments. So they'll, once or twice, I think a day, they will go to an encampment, give notice that that encampment is being is going to be cleaned up, and request that people move. San Francisco law requires that it actually offer shelter to folks before moving them from an encampment. But I'll say there was a dispute between the plaintiffs in San Francisco in this case as to whether or not they actually complied with that law. Plaintiffs, again, sued San Francisco to end these cleanup efforts, saying that San Francisco did not, in fact, offer them shelter, and regardless that the laws criminalize them for being homeless and having nowhere to go. The district court did enjoin San Francisco from conducting sweeps of the encampments, and that decision is currently on appeal. There have been, in the last couple of weeks, there was some movement on this case because the Johnson decision that we were just discussing said that the offering shelter to an individual essentially permits, if the person denies the shelter, then that person can have a law enforced against them. The parties essentially agreed on appeal that as long as a specific offer of available shelter was made against someone, the laws could be enforced against them. The Ninth Circuit adopted that agreement in an order of a couple weeks ago, or about a month ago now. And then a couple weeks ago, the city of San Francisco announced that it would resume its cleanup efforts for encampments. But there are still some lingering issues for the Ninth Circuit to decide on this issue. And specifically, when a city cleans up a specific encampment, there's other public areas where the individual can go. And so the Ninth Circuit still needs to decide whether or not that feature of the law takes it out of the scope of Martin and Johnson and the Eighth Amendment entirely. And so that's sort of another watch this space issue. And that brings us, at long last, to time, place, and manner regulations, which I know probably most of the people in this room are pretty familiar with. Again, footnote 8 of Martin is what we look at oftentimes when we're talking about time, place, and manner restrictions. And as I'm sure you all know, here in Oregon, we're quite familiar with the time, place, and manner restrictions because House Bill 3115 directed cities to enact them. As you can see here is the operative text from House Bill 3115. It says that any city or county law that regulates the acts of sitting, lying, sleeping, or keeping warm and dry outdoors on public property that is open to the public must be objectively reasonable as to time, place, and manner with regards to persons experiencing homelessness. And the key verbiage here is objectively reasonable as to time, place, and manner. And as you all know, HB 3115 directed cities to enact time, place, and manner restrictions by the summer. And in compliance with these HB 3115, cities have enacted just numerous types of regulations. Cities have restricted the types of activities that can occur at campsites. So things like no fires, no drug use, no environmental hazards, no biohazards, and no excavation, digging, things like that. Cities have restricted camping during certain hours. So there are some cities that said, you can camp in parks, but only during the nighttime, tear down the camp, move along. Cities have restricted the types of structures that can be used on campsites. Some have said no tents or no larger structures. Cities have limited the places that camping can occur, so designating things like parks or roadways off limits, school zones, certain protected utilities, things like that. And cities have required that campsites move after a specific amount of time. So if you're on this block for 24 hours, move along. And again, because these laws are relatively new, and this statute in particular is very new, the Oregon courts just have not had the opportunity to flesh out what it means for a law to be objectively reasonable. And so we will be finding out in the next year or so which of these laws the courts are going to uphold under HB 3115 and which ones that are going to be stricken down. I wanted to just point out a couple examples of the types of laws that cities have enacted. So Portland's law on this essentially says that camping can occur at night, but must move along during the day, but must be taken down during the day, so the tents have to come down. And it protects certain areas, so things like parks, roadways, schools, and high crash roads. Ben's ordinance allows camping in public rights-of-way, but says that if you're in a certain public right-of-way for more than 24 hours, you have to move to another block. So there can't be long-established campsites, but you have to move along. And I will say, and I think as my colleague April is going to talk about, these laws are being challenged, and in particular, Portland has recently been sued on their on their time, place, and manner restriction. So it will be interesting to see in the next year or two what courts do with these regulations. And with that, I think I'll turn it over to my colleague, Carrie.
Thanks, Onit. Onit is being a little bit humble when he described himself. He was one of the lead trial lawyers in two trials that happened over the last few months in Oregon, one in federal court, one in state court over the 114 litigation where we represented the state of Oregon. And so I expect that both the U.S. Supreme Court and the Oregon Supreme Court are probably going to be hearing something about those cases in the not too distant future. But Onit isn't just a constitutional scholar, he's a trial lawyer too. Cities, it's great to see you all here today. Some of you are clients, I appreciate you seeing you here. You guys are in the crosshairs of what we see happening with homelessness. Fine, our state legislature can enact laws, right? We can raise all kinds of money to deal with homelessness, but you folks, city councilors, city managers, assistant managers, staff, all of you, I imagine all of you in this room are in here for a reason, because you are in the crosshairs of everything that happens, because you got to deal with the practicalities of homelessness and the struggle that you're seeing in your communities. And it can be heartbreaking, it can be humbling, it can just be a real struggle. And we as lawyers, while we like to look at it in this legal construct, we know that there's real people out there who have good hearts, and you're trying to deal with this stuff in a real compassionate but effective way. And that's the challenge. How do you be effective here? The state of California has spent $20 billion on homelessness over the last 4 years. $20 billion. I could say that 10 times. It's still $20 billion, and it's gotten worse in that state. They have more homelessness now than when they spent the first of those dollars. I don't know how much the state of Oregon has spent. Don't know. I didn't want to go there. But just throwing money at the problem is not going to solve it. In Portland itself, we have conflicts that I think have been played out in the papers a bit between, let's see, the county and intergovernmental agreements with Portland, and just how are we going to get on the same page in Oregon's largest community that has probably the biggest problems about dealing with homelessness. So, again, you're in the crosshairs. The tools that are in your tool belt to deal with these kinds of problems are changing all the time. We thought you had tools in your tool belt that had to do with decades-old policies on land use, right? Land use laws, land use regulations. As we'll see, that's kind of out the window. We now have 3115, which Annette summarized for us. These things are changing daily. And April Stone is going to be up here pretty soon to talk about a very recent lawsuit, again, in the city of Portland, dealing with 3115. We have what I'll call impact litigation. Lawyers are very good, and they have been for decades, if not longer, in this country, of finding ways to have really important impact, public policy impact lawsuits, and we're seeing that, and I'll talk about that a little bit here, impact litigation, where lawyers are trying to affect policies that you have to deal with. Naturally, we have rampant drug addiction, drugs infiltrating into our country, costs very little, and we have mental illness that is causing all of this stuff, right? I'm not going to really comment. I'm not a social scientist. I'm a lawyer. I'll deal with it in that construct, but you guys have to deal with that. So this problem is not going away. It's just not. So is this the little device? Green button. Thank you. All right. So there are all, I don't deal with the appellate stuff. Annette can deal with that. I like to be boots on the ground, these kinds of cases. Been doing this for about 34 years now. But let's just back up for a second to deal with really what took a lot of the tools out of your tool belt. Okay, House Bill 2006 from 2001 was, and is, a statute dealing with emergency shelters, okay? Typically, there would be all kinds of state and local regulations about where you're gonna put a homeless shelter and what's gonna have to be done to site a shelter within a community. HB 2006 kind of took a lot of those tools away. It said, number one, if there's an application to open a shelter, you absolutely have to approve that, subject to some exceptions or some conditions, which aren't that hard to meet. I've had litigation over this. What do they have to show in the application? Pretty simple. Okay, there's sleeping and there's restroom facilities planned for this shelter. Okay, pretty simple. It will comply, not it does comply, but it will comply in the future with building codes. If they can, show that, yeah, they have plans to comply, boom, approved. Is there adequate transportation around the area of this site to get to key, types of infrastructure like commercial and medical services? Fine. That's not hard to show. It won't pose an unreasonable risk to public safety. It's pretty easy for the community who's ever making the decision to simply say, yeah, that's proven. They say it's not going to cause a harm. In fact, it's going to help because now we're putting people, instead of being on the sidewalks, being in the parks, we're putting them in a shelter. If they can show those minimal factors, boom, got to approve the shelter. And one of the biggest challenges to this is this can all be done with zero public process. And you guys are all about public process, right? Following the public meeting laws, giving all the public notice. You got lawyers sitting there on the dais with you, right, to make sure you follow all the laws with. how you're going to consider people who are testifying about giving the public process, the public themselves, a voice in these kinds of decisions. There doesn't have to be any public voice whatsoever, which is a huge, huge problem for your constituents, right? So, hypothetically, if a city council just wants to delegate to somebody else the decision-making for, are we going to, let's say, lease a piece of property or buy a piece of property and have a shelter built there, right? That doesn't have to go to council at all, theoretically. Doesn't have to be any meeting over it. No testimony from the neighbors, from the local church, from people who are concerned about the schools that it might be near. None of that. This statute took all of that away. There doesn't have to be any public process. You have to approve it. And boom, maybe some of you had to deal with this. I don't know, but those kinds of tools in your tool belt, that kind of public process for public meetings can all be taken away. And that is a real challenge. Another thing is that the statute says these are supposed to be temporary shelters, okay? No judgment here, but what's temporary mean, right? Is that a year? Is that 3? Is it 10? What does temporary mean? The statute doesn't say. And I guess I would ask people to think about around this room, for those of you who are aware of shelters that have opened, have any of them closed, right? And when will that be? This is a snowball that we're dealing with here, as California's expenditure of money has shown us. And the more services we provide, and again, I'm not the social scientist, but I think what evidence is proving to us is that the more services we provide, the more need there will be. It's like, how do we solve that problem? I don't know. That's for you guys to deal with. We're just trying to deal with it from the legal perspective. And it's a real challenge, and it's not going away. So that's HB 2006. Tools in your belt, now gone. So what are we seeing? There's a lawsuit that was filed in Portland, a class action case filed by the Davis Wright Tremaine firm, alleging that all of the blockages that we were seeing on our sidewalks, and frankly are still seeing on our sidewalks, this is a picture out of their complaint, and there's a few of them here. I'll just click through. They included some pictures on Portland sidewalks, and I can back up here. The purpose of this complaint was to say, hey, people who have disabilities can't get around our city because the sidewalks are blocked in many instances, right? Either an individual encampment or bigger encampments, they're blocking the sidewalks, as this picture shows. So somebody who's in a wheelchair or on crutches or whatever it is, somebody who's disabled, they can't get around our city. And so somebody, and this would be impact litigation, right? Somebody in a firm in Portland had a great idea. Well, what about the ADA, the Americans with Disabilities Act? They have rights to get around our city on our city sidewalks. And so I thought, well, maybe one way of challenging encampments, as opposed to just, hey, let's have all kinds of shelter sites. A lot of these people don't want to go to shelters. They just don't want to be in shelters. We could have all the shelters in the world, and some people aren't going to want to go. And so we have this. How do we deal with that? And the idea was a class action lawsuit on behalf of people who are disabled and on behalf of people who care for people who are disabled to force the city, now again, city's in the crosshairs, right? Force the city to do something about camping on sidewalks. And it was a very creative lawsuit, and it was very effective. The federal judge in the case, Judge Mossman, immediately threw this case into mediation. I've looked at the docket. They went to mediation again and again and again and again, and finally hammered out a settlement. And what's it going to cost the city? It's going to cost them $20 million plus to deal with this lawsuit because they settled the case. And then they entered into all kinds of wonderful terms to deal with trying to clear as best they could, or at least manage the sidewalk encampments. So I read through the settlement. If anybody wants a copy of it, let me know. I can email it to you. But the city entered into an agreement to have an impact reduction program. And what that meant is the first year of the agreement, they were going to spend no less than $8 million on this impact reduction program. And then then for the following years, it was $3 million for each year, totaling up to $20 million bucks. And the impact reduction program involved a lot of different terms. I've summarized some of them here on the screen. But one is there's going to be a 311 operator system manned by live people who can take phone calls, complaints about camping on sidewalks. And then there's going to be an online program where people can report online and a website. They have to set all that up, pay for that for years to come. There were terms that say that, okay, the city can't distribute tents to people, subject to exceptions. So for example, if there's a cold weather event that's coming in, the city can still distribute tents to people who are homeless. But there's severe limitations. And this kind of brought about highlighted the fact that there was inconsistency between different government bodies in the Portland area. Some were actually cleaning up encampments, taking away tents, trying to get people into shelters, while another part of the government was actually distributing tents, and so they were just at cross purposes. Here, in this settlement agreement was, no, there can be no tent distribution by the city of Portland. Campsite removal was part of this. One of the things that the city agreed to was we have to, at a minimum, take away 500 tents in any given year. Encampments, excuse me, not tents, encampments in any given year. They had to install signs in areas where this is, where there's a lot of this going on. And there's a reporting function. So $20 million bucks plus, and then on top of that, we lawyers are expensive, right? And so we're very expensive. Can't afford myself. And so the law firm in that case filed a motion with the federal court for an award of attorney's fees because the settlement agreement said the plaintiffs in the case are the prevailing party. The city agreed to that. Plaintiffs have prevailed through the settlement, and their lawyers get to apply to the court for an award of attorney's fees. The docket, I read through it, there's been motion after motion after motion and supporting declarations to support the request for an award of almost $700,000 in fees for the case, and the judge hasn't ruled on it yet. It looks to me like it's fully briefed before Judge Mossman, ready for a hearing, ready for a decision. That's a lot of money. I mean, for most cities in the state, I imagine that's got to be more than the legal budget for the year. This is one case for the city of Portland. And so it's, this is just daunting stuff that cities have to deal with. And great, city, Portland's the biggest city, maybe they have the best funding, but you guys have to deal with all this stuff too. Grants Pass has been hit with this impact litigation, right? Small community. This is real dollars that we're dealing with here and real lives. So it's not going away. I sympathize with you. This is a lot of hard work on it, and April and Hannah up here, we're all here to talk to you about what can you do with the laws that are changing, frankly, daily sometimes, the decisions that are coming out. But I'm going to pass it along to April, April Stone, who has been studying some other lawsuits, one in Phoenix, another one that was just filed, I don't know, a week ago maybe, in the city of Portland, to give you some more context for what's happening in the legal world around homelessness. So, thank you. Hannah? Excuse me, April?
Good afternoon. I'm April Stone, and like my colleagues, I'm a complex business litigator that spends a fair amount of time doing work on cases involving state and local governments. And I realized the title of our presentation is the top 3 legal issues, which now I'm realizing are homelessness, and you guessed it. And some First Amendment issues that we'll get to. So maybe homelessness, and First Amendment issues. But there are a couple of variations on some of the problems that both Anna and Carrie have discussed that are worth mentioning. First, I wanted to kind of highlight a couple of risks that have come out of these statutes and the resulting city ordinances that various cities in Oregon and beyond in the Ninth Circuit have enacted to sort of try to comply with these time, place, and manner restrictions. The statute that resulted from House Bill 3115 is important because it has a provision in it that allows a prevailing plaintiff, which would be the person experiencing homelessness in this situation, to recover their attorney's fees if they prevail. So like Carrie mentioned, that can be a huge bill, particularly when it's a class action lawsuit. And these are becoming more and more common in settings like this, where folks without a lot of resources, they need to kind of come together in these class action lawsuits to affect change. So one of the things to, I guess, be aware of is that while there's not a lot, there's some tiptoeing and weaving about what you can do. One of the things you can't do is nothing. So getting sued and getting hit with attorney's fees if the court finds that your restrictions were unreasonable is a risk to be aware of. Another risk is the risk of conflicting court judgments. And I'm going to talk a little bit about a couple cases that will highlight those. This one's from out of Oregon. The city of Phoenix had a problem with folks experiencing homelessness in an area called the Zone. And it became, a case was brought under the Martin and Johnson line of cases that Annette discussed, that in federal court, and they obtained an injunction, sorry, I'm struggling here. They obtained an injunction that says, there's not enough beds available, so you can't move these folks out of the zone. But they did allow the city to sort of move folks a short distance so that they could sanitize the area. And after one of these sweeps, a local business owner erected a giant dinosaur statue on the sidewalks so that folks could not move in and return the encampments there. So the city started enforcing land use ordinances against this business owner and basically citing him for having this dinosaur structure in the public right-of-way. And so this business owner kind of came together with some other business owners around the zone to do something about the problems that homelessness in the area was causing to their businesses. So they brought an action in state court and alleged that the homelessness situation in the area of the zone was a public nuisance. The state court issued a preliminary injunction that says, you gotta do something about this public nuisance. So the city of Phoenix is now in this situation where they have a federal injunction saying you can't clean up homeless encampments, and then you have one that says you have to between the state and federal court. So what do you do now? You wait and see what the courts see. So this case is, both of the injunctions have been appealed by the city. One is on appeal in the Ninth Circuit, the other in the Court of Appeals in Arizona. Follow along and see what the courts decide must be done in Phoenix. But a little closer to home, we have Portland's time, place, and manner restrictions are under scrutiny in the state courts here. So the city of Grants Pass case that resulted in these Ninth Circuit rules that say your time, place, and manner restrictions have to be objectively reasonable. So Portland's effort to enact one of these ordinances that is objectively reasonable was Portland City Code 14A.50.020, and it has all these lists of time, place, and manner restrictions. But the gist of them are no camping between 8 a.m. and 8 p.m. At 8 p.m., you can camp on public spaces as long as you clean up at 8 a.m. and everything's gone. There are other rules about how many inoperable cars and bicycles and car parts and bicycles that are designed to kind of deal with the unsightliness of encampments. But a group of unhoused individuals filed a class action lawsuit in state court against the city of Portland, alleging that they basically allege two claims. The first is that Portland's ordinance violates the objective reasonableness requirement of the time, place, and manner restrictions. And the second claim is that the penalties imposed under Portland City Ordinance are unconstitutional under the Oregon Constitution. So the Oregon Constitution in Article 1, Section 16, has a similar provision to the Eighth Amendment that deals with cruel and unusual punishments and excessive fines. So this is not under the cruel and unusual punishment prong of Article 1, Section 16. It's under the excessive fines. So the fines, the ordinance, the penalties under the ordinance are that the first two times you violate, you get a written warning, and the third time and beyond, you can be fined $100 or sentenced with 30 days in jail, or both. So the lawsuit alleges that that's an excessive fine and that folks can't possibly comply because they have too many things. How can we clean up our whole area? And 8 a.m. is just, there's nowhere for anyone to go with all of their stuff other than public spaces between 8 a.m. and 8 p.m., so how could this possibly work? So the claim is filed in the court. The plaintiff sought a preliminary injunction, a temporary restraining order, which is a precursor to an injunction and another form of injunction. The court heard the motion last week and found that because the city of Portland has announced publicly that it will not enforce the ordinance yet, and that when it decides to start enforcing the ordinance, it will give folks a 2-week warning before enforcement, that there was no real risk of irreparable harm, which is the showing you have to make to get an injunction. There's no risk of irreparable harm because it's not being enforced anyway. So there's no injunction in that one, but as soon as Portland announces that they're going to start enforcing the ordinance, I would expect a follow-up motion to get an injunction enjoining enforcement of that ordinance. So we're stuck between a rock and a hard place. And Arizona's even worse off. So City of Phoenix is even worse off. So again, apologies for no clear answers, but these are things to just pay attention to. And the claim under the Oregon Constitution, these line of cases coming out of the Ninth Circuit, although they relate to similar federal constitutional and state constitutional provisions that are very much similar, the Oregon Supreme Court is by no means bound to follow what the Ninth Circuit did. So we could get a different analysis coming out of the Oregon Supreme Court than we have currently in place from the Ninth Circuit. So a couple things to follow along and look out for. And with that, I'm going to hand it over to my colleague Hannah Hoffman, who has much more fun things to do with us.
Hi, my name is Hannah Hoffman, and like my colleagues, I am an attorney at Markowitz Herbold, and unlike my colleagues, I am not going to talk about homelessness, unless you ask me to. I'm going to do something a little bit different. My assignment, I'm the third topic, and the third topic is the First Amendment, as well as public records and public meetings in Oregon. And this is a topic I could probably talk to you about for about an hour. I mean, I could talk to you about it all day, and I wouldn't tell you everything that exists in that space. I also wouldn't tell you everything that you actually need to know about it, because the First Amendment is a very fact-specific area of law. Most cases turn on really specific facts that don't necessarily come up again in another context. So usually when I do these presentations, what happens is a vacuum starts up outside. And in addition to that, everybody in the audience ends up asking a lot of questions because they have some really specific thing that they're dealing with or wondering about, or a specific question somebody has asked them. And it kind of turns into a Q&A session. So we've decided to embrace it this time, and I have a wheel of First Amendment topics, which Anand is going to spin for me. He didn't know that before just now. And we're going to pick a topic, and you guys are going to ask me whatever you want to, and we're calling this Stump the Lawyer. And you might stump me. I am not an encyclopedia. And if I don't know the answer, I will tell you. But you can feel free to ask me what you want, because it's probably going to be more useful to you to do this than to listen to me give you a PowerPoint about public records law. So what is our first topic? Sure. Yes, I think it should. Let's see. It says speech. Can I say this? All right, speech. So this topic is about what can people say? Yes.
Is it permissible for a censure provision for a city councilor to include no, not to be recognized? Is it permissible for a censure provision to include the provision that the councilor is not to be recognized to speak at any city meeting for an indefinite period of time?
So I understand you have a city councilor who has been basically excommunicated and isn't being recognized at meetings? Okay. So you probably have two issues there. One is that the councilor is a public meeting. The councilor has some right to speak at a public meeting. The other problem that you actually probably have is that the right of the citizens to representation is potentially being infringed in that situation. So we have a representative democracy. That councilor has been elected to represent their constituents. And if they are not being allowed to participate in meetings, arguably the constituents who voted for them, it's really actually their rights that are most in concern in that situation. Some of how city councils are run has to do with the bylaws. The First Amendment doesn't have a lot to say about exactly how councilors interact with each other, but it is a public meeting, it is a public body, and the citizens do have a right to have the person they elected actually represent them. So I think you probably do have a few problems there, and it would be a good question for your city attorney to explore further. All right. Any other? Yes.
Can you limit how long a councilor wants to talk if you ask for feedback? Can you limit the amount of time a councilor wants to talk if somebody just likes going on and on and on and on about a topic?
You probably can. So you can restrict how long your constituents talk. So for example, during a public comment session, you can set it to 2 minutes. And again, you'd want to take a look at your council's bylaws because it may speak to this, but assuming the bylaws are silent on this issue, you could probably impose a rule that says, you know, the councilors are also going to limit themselves to 2 minutes for this meeting so that the public has a chance to talk. You know, you don't want to frame it like so-and-so is a windbag, but you can, time limits are usually fine. The First Amendment doesn't really mind a time limit most of the time. Yes?
We've had, during public comments, sorry, Leo Groner, West Lynn. We've had, during public comments, someone submit a written document and ask that a counselor read it aloud at the meeting. It seems to me if I'm a counselor and I radically disagree with the document, am I required to read their document?
So what you are required to do is treat everyone the same. So if you read everyone else's document into the record, but not this one that you disagree with, that would not be okay, because that would be called viewpoint discrimination, which is where the government chooses between viewpoints that it agrees with or that it likes. But it is perfectly okay to have a policy that says that you will take written testimony, but categorically will not read it into the record. You can have any reason you want to for that. It can be a time saver. It can be just for redundancy's sake. The written testimony is part of the record when it's submitted to the council. The most important thing is that you treat everybody the same. And what you can also do is if your city council has, of course it has multiple members, you could always split it up amongst yourselves about who reads what if you do want to read them out loud and make sure everybody's just reading something that they personally, it doesn't really matter which one of you reads it, but it does matter that the city council treats everybody exactly the same, if that makes sense. Yes?
Good day, thank you. My name is Christopher Lopez, City of Monmouth, and my question is about written testimony in the context of an online meeting. So many of us are engaging in online or hybrid meetings, and oftentimes you'll see either the chat enabled or disabled. I've seen the chat used either for, running questions in less formal proceedings. I've seen the chat used just to share information and documents in more formal proceedings. And then in other areas, attorneys have counseled that it's illegal to use the chat at all in public meetings. Clearly conflicting opinions from multiple attorneys in different public bodies. What is your take on this?
Can you tell me why it would be illegal to use the chat? Has anyone told you why?
I can't tell you why.
Okay. So my take would be that you can either use the chat or not use the chat, and either one is fine. So just like you don't have to have a public comment session. So the First Amendment doesn't require you to have a public comment session in a regular meeting. Your bylaws might require it. You would want to check those. If your bylaws require public comment at meetings, you probably do need to run the chat or in some other way allow people to talk to the city councilors. But you can do it in the same way that you would do a public comment session. So for example, you could have the chat open for the first 30 minutes and allow people to engage that way and then turn off the chat. If your bylaws don't require a public comment session, there's really no First Amendment right to address the city council during a meeting. A city council meeting is what's called a limited public forum. It means that the government has sort of voluntarily opened up this space for people to talk to it, but it has a lot of control over what that looks like. So you can run the chat. If the chat is open, you have to let everybody participate in it, and you can't sort them out based on what they're saying. You can keep the chat closed. You can keep it open for some period of time and then close it. You do probably want to be careful. What people say in the chat is arguably a public record because it's during a public meeting. So you want to find a way to preserve the chat. I think that is possible in most programs. But as long as you do it sort of thoughtfully and know why you're running it or not running it, it's honestly fine either way, at least from the First Amendment perspective. Anybody else? Sure, why don't we spin again? April wants to spin it this time. On it, don't do it. Okay, we've got the press. Yes, you have a question.
What constitutes or defines the press, especially as it relates to your executive sessions?
So that is a great question. And I used to be a newspaper reporter, so I've been to a whole bunch of executive sessions. So this has always been a really tricky topic. It always has been. The criteria has usually been that somebody works for a publication with some amount of public circulation. So it's not just a personal blog, it has a circulation of some size that people, that the general public would be reading. Because the purpose of the executive session is to allow the press to have some idea what's going on behind closed doors so that they can inform the public about it, because the public is not allowed to be there. When I was a reporter, which was a while ago now, the big question was sort of bloggers. You know, back in the day when somebody had their WordPress blog and only their mom read it, and did they count as the press? And the answer always seemed to be whether there was some professional quality to the reporting and whether it had a circulation for its publication that was of some size that would matter. Nowadays, everybody has a cell phone and arguably could consider themselves a reporter because they are recording things. The law is certainly not written to include everyone. So the same principle probably still applies. Are they employed by a publication that has a circulation of a significant size in the community? Are they reporting on, say, a documentary that is going to be distributed to a wider public audience? Some amount of public reach for the publication that they work for is typically what most public bodies look for. It is not an exact science, but how many people they're reaching is usually the best guide.
So Facebook page would probably qualify as a limited blog.
It would depend, and it would also sort of depend a little bit on the Facebook page. If someone is engaging in original reporting, you know, you see their Facebook page, they're investigating and writing their own articles, and it has a wide following of 20,000 people, then probably. If the Facebook page is dedicated primarily to reposting news articles from other places and sort of commenting on them, that probably isn't the press. You're looking for somebody who is creating their own content, doing their own investigation, their own research, and they're not just sort of commenting on what other people are publishing, if that's helpful. Okay. Any other questions about the press? Yes.
Reporters should have credentials of some kind showing their official job.
Well, that's a great question, and actually the First Amendment doesn't allow credentials for reporters. The question is whether a reporter should have credentials to show that they are a reporter. And actually the First Amendment does not allow the government anyway to give credentials, like a license, to a reporter. Credentials are usually given by a private body or, like, for example, in the White House press corps, those credentials are so that they have access to a particular space. They rent, like, office space in the building, and they have to go through a security clearance in order to do that. So you get a credential that basically says you're allowed to be here and the Secret Service isn't going to have you escorted out of the building. But there is no license to be a reporter, and I have a license to be an attorney, but when I was a reporter, there is no test, there's no license, and the government is actually not allowed to do that. Yeah, it's a great question.
If there's an article that appears on the front page of the paper, this would be The World in Coos Bay, North Bend. I'm a counselor in North Bend. And the article concerns my work on the city council. Is the reporter, if he doesn't call me for comment, is that a problem? Are they supposed to call the person that they're writing about for comment, or can they just freelance it? Just purely going off what they see on the video, not particularly asking for any background or anything like that? I guess that's a pertinent question.
Yeah. So first of all, I love Coos Bay. I grew up in Gold Beach, born and raised there. So, you know, we're kind of neighbors in a way, you know, the South Coast. So that's a great question. Technically, reporters can do whatever they want because unlike an attorney, they aren't licensed and there isn't actually, beyond them publishing something that's actually inaccurate, there aren't really any recourses, so they don't have to talk to you. There's no actual requirement. What there is, though, there's a group called the Society of Professional Journalists. It's a little like the Bar Association, but it's a little less formal, and it has a code of ethics for journalists. And it's not something that anybody could really enforce necessarily, but that code of ethics does require you to, requires you to engage in fair tactics in reporting, and it requires you to get information from multiple sources, and it requires you to treat your sources with fairness, like from a person-to-person perspective. And writing about a video of a city councilor without calling them or attempting to talk to them first, I mean, sometimes you attempt and you miss them and it's too late in the day and you just can't get there. But without even trying to talk to the subject of the article, that is the kind of thing that ethics code speaks to. And it is a conversation worth having with that reporter because that's not the kind of behavior they are generally expected to and hoping to engage in, if that makes sense. Yes. Great, last question, okay.
Thank you. A member of the press attends a executive session. Subsequently, that member of the press conveys something that happens during the executive session. Given that there's no penalty, really, for doing so, could a government agency prohibit that individual from attending future executive sessions, but still allow the publishing press to send another individual in their place?
That is a great question, and I believe the answer is yes. I think, if I remember correctly, I think the idea is you have to allow the publication to be there, not necessarily that individual reporter. And in some other sort of analogous situations, like an embargoed press release, publications who break the embargo often don't get the press release the next time. They're not entitled to that embargo. So, like I said, you did stump me a little bit. I haven't reviewed this part of the Public Meetings Manual in a long time, but I don't think that you have to allow that specific reporter at your executive session if they have breached the confidentiality of the session. All right, so that was our last question, and I believe it is time, and I think this is the end of your day, so congratulations.
Please give them a round of applause.
And thank you for having us.
So we do have a couple of just notes for the crowd. Please take a moment in your app to give feedback to the session. If you have any questions, you can ask me after the break. Up next on the conference is the awards dinner. The doors open at 5:30 with dinner beginning at 6 p.m. If you are not registered to attend the awards dinner and would like to attend, visit the registration desk to check ticket availability. And the last event of the evening, please join LOC President Calloway at the President's Reception in the Top Golf Lounge from 8 p.m. to 10 p.m. Dessert and drinks will be served. Thank you so much for attending. If you have any questions, I think there'll be some availability at the end. But thank you so much, and have a great evening.